Whistleblower disclosures, do they have to be in writing? I get this question a lot. And there's a technical answer, and then there's a real answer. Technically, no. Your whistleblower disclosures do not have to be in writing, meaning if you made a verbal disclosure about fraud, waste, or abuse, and you made it to your supervisor if you're a federal employee, or you made it to a third-party agency if you're in private employment, a judge and a jury could believe you that you actually made that disclosure. That's the technical answer. The real answer is, in most cases, you will likely lose. And the reason for that is you have to understand the three-step analysis that whistleblower cases encompass. And the first step of the analysis is the burden of proof is on the employee to demonstrate that he made the disclosure, and the employee has to prove it by preponderance of evidence. Second, once a judge or jury finds in favor of the employee by preponderance of evidence that he made the disclosure, there is a question of, was the disclosure a contributing factor in whatever happened to that employee? And the Merit Systems Protection Board has a two-step test for that. A, did the person he made the disclosure against take the action against him? And B, was that done within a reasonable time following making the disclosure? And in many cases, that is an easy element to prove. You don't really need much more than I complained about Mr. Smith, my terrible boss, and that he was committing fraud against the government. A week later, I found myself moved to Siberia, which is a technical term, or not a technical term, but it's a funny term for what the federal government does to people. Is they take some very high-level manager who made a disclosure. They don't fire him. Instead, they move him, usually it's to like some sort of basement office without any windows. And generally, there's no one else on the floor that he's working on to talk to. And they have the guy, I knew one guy I talked to at a bagel shop once who said this happened to a friend of his. And he was assigned to test software that was from the 1970s. And the federal agencies do that to people. Another thing they may do is they may take away all of the employees' duties and have the person's one job, which is to stay current in the field of whatever that person is. So if he's a nuclear engineer in the field of nuclear engineering, this person has to now read up on all of these manuals and all of these latest publications, which is really a nothing job because he's not going to be assigned to anything. So what's the point of that? That's step two. Step three is, did the agency prove? Now, again, steps 1 and 2, the burden of proof is on the employee. Step 3, the burden of proof is on the agency. It's on the employer. And it's a very high level of proof. They have to prove by clear and convincing evidence, which is more than preponderance of evidence. They have to prove that they would have taken the same action against the employee anyway. So you have to understand this. Once a judge finds that you made the disclosure, it is hard for the agency to win those cases, because usually there is some sort of retaliation that's taken that can be shown in step 2. It happens soon after. I mean, obviously, if someone blew the whistle on something and then came to my office and said 4 years later they took this action against me, I'm not going to take the case because that person is not going to make element number 2. The only good cases are where the action happened soon after the disclosure. But in any event, element number 3 has the burden of proof on the agency. So if the agency can't meet it, you will win the case. And therefore, putting your disclosures in writing is really critical, because the only way the judge could rule against the employee is by finding that the employee did not make the disclosure. I get this question. I didn't put the disclosure in writing, but circumstances would show that I was retaliated against. Okay, let's take a look at a typical fact pattern there. The employee's been working for Department of Energy for 20 years. And during that time, he was promoted many times. He's now an SES, and he's well respected. He manages a team of subject matter experts, and unquestionably, this person is a prince over in Rockville. Here's what happens. He makes a disclosure. A week later, he's sent down to Siberia. Okay? And now the question is, can he say, listen, I would not have been sent to Siberia but for the disclosure. And in fact, if you look and if you study the reason that my supervisor sent me to Siberia, what you'll find, Mr. Administrative Law Judge, is it's totally not believable. And therefore, what is the likely explanation? The likely explanation is the reason that he did it is to get back at me for blowing the whistle on him. Well, that seems very logical and good, and that should make a lot of sense. The problem with it is administrative law judges don't rule that way. They don't look at the consequence of what happened and make that common sense, logical question. They separate the elements of the case and they look at, did you put it in writing? Now, I know that doesn't make any sense, and that denies justice to a lot of people. I agree with you. That's the system, and you have to work within that system, and if you don't, you will lose. Finally, I get this question or this comment all the time from particularly federal employees. I would have put it in writing, but I was scared. I was fearful that someone would find that email and that would get so-and-so in trouble. Okay, and possibly then, once there was something in writing for me, I would be retaliated against. This is another argument from the employee that will generally lose. The whole point of being a whistleblower is, in spite of the fear, you blew the whistle. That's a lousy explanation that the courts don't apply. And even though it may make a lot of sense, and you see all the time, that's the point, though, is that the written thing has a record that it's beyond dispute. That's what happened. And that's the element of the case that's really also up to the employee, more so than the agency. And once the employee captures that element, the chances of winning are going to go way, way up for that employee.